CBD, extracted from cannabis, concentrated, and sold as a solution, pills, gummy bears, mascara, dark chocolate salted caramel almonds, and so much more. You've probably seen CBD oil in your local CVS or gas station. That's because, in lots of cases, it's legal, potentially foreshadowing lots of other products that could soon be available nationwide, transforming a market already worth $20 billion into so much more. But what if I told you that CBD oil was invented in 2017? You'd probably tell me I'm crazy. But the US patent system and one particularly ambitious company might disagree. And depending on how a district court case in Colorado goes, this might only be the beginning. This video is about that case, as well as the more general, wild world of IP law. And despite the bizarre situation, it's a pretty serious topic, with some intense implications, so we'll try to keep it serious. How do we get here? The story involves 200 years of US intellectual property law, genetically modified DNA, and a whole bunch of judges pretending they know about science. Strap in. Intellectual property lawyers argue about a lot of stuff. That grumbling you hear is every IP lawyer watching this video getting ready to pop off in the comment section. But if you ask them what grounding exists for their jobs, at least in the United States, they'd probably point you to the Constitution. Specifically, Article 1, Section 8, Clause 8, which grants Congress the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. At its most basic level, IP law is created to ensure innovators get rewarded enough to keep working, incentivizing them to keep creating cool new things. The balance, then, is kind of like a tug of war. Good IP law ensures that inventors get enough protections, market or otherwise, to continue producing, and encourage their successors to do the same, while also not unfairly knocking other people out of the market and making sure that other people can actually use new products in a way that makes them, well, useful. For example, it's good to incentivize the production of a new piece of technology, but if no one else can sell it for 1,000 years, maybe it's not doing as much good as it can, and that's too much protection. The question of incentives dictates the rules around patents, which gives the sole right of manufacturers to sell an invention to its owner for a certain amount of time. In the US, this is generally 20 years. So what does any of this have to do with CBD oil? Let's get introduced to the case, called United Cannabis Corporation v. Pure Hemp Collective. It all started when Pure Hemp Collective, a Colorado-based cannabis company, made some CBD oil. You've probably seen this stuff in your local CVS and or gas station. It's pretty common. So imagine Pure Hemp's surprise when they got hit with a big fat lawsuit for selling CBD oil. See, there was this other company called United Cannabis Corporation, or UCAN. They're also from Colorado, and they also make CBD oil. The difference? They got a patent. Specifically, US patent number 9,730,911, a number so long that even bodies as boring and detail-oriented as district courts can't be bothered to say it. So we'll call it what they did, Patent 911. What's in this patent? Well, a whole lot of stuff. But broadly, any proprietary liquid formulations of highly enriched extracts of plant cannabinoids with or without specific combinations of cannabis-derived terpenes, otherwise known as the stuff that makes CBD seem fragrant, is protected. Over 30 different claims make claims to different types of cannabis extracts and methods of prepping and using the same, formulated for oral, sublingual, or topical administration. When Pure Hemp came to market with CBD oil products then, UCAN tried to say that you couldn't do that. They owned monopolies on almost all of these things. Pure Hemp, thinking there's no way you possibly invented this, said it's ridiculous. Only one thing left to do. Fight. So, where are we with the decision? We haven't gotten a final ruling yet, but frankly, we're far enough along that it should scare us a bit. The most recent decision we've gotten out of the case was in April 2019. This is for what's called a motion for summary judgment, which is essentially a way for one party to yeet out of a lawsuit if the movement shows that there is no genuine dispute as to any material fact and the movement disentitled to judgment as a matter of law. Putting this in legible terms, parties can win early motions for summary judgment if there's nothing to plaintiff's claims. The problem is, when Pure Hemp asked for one of these, it wasn't granted. So when UCAN tried to claim it owned all CBD oil and Pure Hemp said, come on now, the U.S. District Court of Colorado said, well, they could be right. So now you may be thinking, why can someone patent CBD oil when it's essentially just chemicals from cannabis put into a liquid? Generally, you're on the right track. Patent law has provisions about products of nature to protect against this sort of thing. The Supreme Court has said that laws of nature, natural phenomena, and abstract ideas are all patent ineligible. It reaffirmed this as recently as 2014 in a case called Alice Corp v. CLS Bank. That said, the reason the motion for summary judgment failed is, in the end, that the court didn't believe that the 911 patent was directed to one of those patent-ineligible concepts. To prove this, it drew on a two-step test that was formally articulated in that same 2014 Supreme Court case, Alice v. CLS. When trying to figure out if something is patentable, the first step is to question whether the claims at issue were directed to one of those patent-ineligible concepts listed before you even think about whether it's an inventive concept that builds beyond those ideas. The UCAN case alleges that the 911 patent doesn't pass the first test. Why? Because, as argued by UCAN, the claims are not directed to the laws of nature or natural phenomena, because they claim human-modified liquid formulations that require converting solid cannabinoids into a different state with markedly different physiological characteristics. The court bought this pretty hard. The notion that the liquid formulation itself is supposedly novel was enough to dissociate from the products of nature claim entirely. Quoting from the decision, "Pure hemp has failed to establish beyond genuine dispute that a liquefied version of cannabinoids and related chemicals at the concentration specified in the 911 patent is anything like a natural phenomenon. Pure hemp nowhere claims that these precise threshold concentrations, or anything close to them, occur in liquid form in nature." It's not like the court didn't see how ridiculous this sounds. To be clear, it said, the court sees reason to question whether the 911 patent claims anything novel, useful, or non-obvious, but it was bound to the Alice test, and along those lines, the 911 patent is not directed to an unpatentable law of nature, a natural phenomenon, or an abstract idea. Instead, it is directed to a non-naturally occurring delivery method of naturally occurring chemicals in, as far as the record reveals, non-naturally occurring proportions and concentrations. Confused? So is the federal judiciary. At least a little bit. They admitted that the proper application of the Supreme Court's Alice standard is an evolving and sometimes hazy area of law. But the reason they went with the call they did, that the liquid form and concentration were enough to make something new, goes back to precedent. Check this out. In one case in 1948, Funk Brothers v. Callow Inoculant, the Supreme Court held that a specific combination of bacteria couldn't be patented because their qualities are part of the storehouse of knowledge of all men. But if you make a thing from scratch, the court has higher odds of granting you a patent. In Diamond v. Chakrabarty in 1980, an inventor genetically engineered a new bacterium to help clean up oil spills more effectively than the rest. The Supreme Court gave the inventor the patent protections in large part because the new bacteria was definitionally not an old product of nature. Remember that the claim was that CBD was super concentrated and liquefied in a way that doesn't occur in nature, and the court's bar for what constitutes man-made is currently quite low. Consider another case that the Supreme Court ruled on pretty recently, Association for Molecular Pathology v. Myriad Genetics in 2012. Take DNA. While there are many ways you can subdivide DNA's components, one way to do it is between exons, which code for amino acids, and introns, which don't. Myriad Genetics Incorporated was trying to synthesize proteins, and by extension, the amino acids that are proteins' building blocks. In this process, Myriad created exons-only strands of nucleotides, which form DNA, and called it complementary DNA, or cDNA. This was all good and well until they tried to patent it, and a whole bunch of scientists freaked out. But the court decided for Myriad, and its logic defending the patent is really telling. Quote, "cDNA is patent eligible because of its markedly different characteristics from any found in nature. Its creation results in an exons-only molecule, which is not naturally occurring. Its order of the exons may be dictated by nature, but the lab technician unquestionably creates something new when introns are removed from a DNA sequence to make cDNA." Taking a step back and understanding what's being said is really important here. As SCOTUS says, this measure created some sequences that were functionally the same as DNA, but they'd just gotten rid of introns, which everyone agreed were functionally useless for this. This suggests a scary precedent for what constitutes a man-made creation. Even if all materials are readily found in nature, you can still call it your own. Of course, it's easy to see the problems that could potentially emerge if UCAN's patent holds for real. If all you have to do to make a patent is super isolate a compound and change its state of nature, that's a little alarming. It gets even scarier when you realize that the people with the legal and mechanical resources to capitalize on these protections will definitely be already wealthy and powerful corporate interests. They'll be able to monopolize markets for years without having really done much innovation of anything. More immediately, it's also scary for the marijuana market that this patent might hold up. If it does, it could start a rush for such stifling controls right when the industry is being increasingly legalized nationwide. Hopefully, there will be some benefits to this case coming right when cannabis jurisprudence is emerging. Maybe this case can expose absurdities in IP law that weren't as obvious earlier. Maybe it's a little more approachable than cDNA, introns, and exons. With it, maybe there's a chance to redraw a broken system. Look, when even district court justices call an area of law hazy, maybe it's time to redraft it. After all, law at its most fundamental level is supposed to offer rules for our lives. If nobody can understand IP's do's and don'ts, then there's no way that these incentives can be expected to work as well as they otherwise could if we all understood the game we were playing. I don't pretend that I have any answers to this, but they've got to be around, and they've got to be better than this. Either way, the next few years of patent law will determine a whole lot, effectively the whole sector. Only time will tell whether protections like patents on things like CBD oil will go, well, up in smoke.